All rise. Oyez, oyez, oyez. All having business before the Honorable Wabash College Moot Court, draw near, for the court is now in session. The Honorable Justices Petrie, Pryor, Felix, and Bravo presiding.
Thank you. You may be seated.
Okay. Good evening, and welcome to the 32nd Wabash College Moot Court Finals. This competition is sponsored by the Wabash College Rhetoric Department and the Wabash Club of Indianapolis. My name is Chris Anderson. I'm the director of Wabash Democracy and Public Discourse, a faculty member in the Rhetoric Department, and this year's campus organizer in training. At this point, I please ask you to make sure your cell phones are turned to silent or off as we begin tonight's program to make sure we do not interrupt the court's proceedings. For those of you unfamiliar with Wabash College's Moot Court, the competition simulates an oral argument at the Supreme Court of the United States. Before we begin, I want to offer what is inevitably going to be an incomplete list of thank yous to people who make this competition possible. There's a deep well of Indiana lawyers who give their time as judges, Julia Phipps, Amber King, and Pam Sacco, who give their time and talents in order to bring order to this process, John Pachter for his work on tonight's program and his efforts beyond, Scott Himsel for preparing these talented students who we will see tonight, and Jane Ann Himsel, who was gracious enough to generate the problem for this moot court based on a real court proceedings currently headed to the Supreme Court. Please join me in recognizing these and many more for their hard work to make this event possible. This year's case, Simplified, asks if the president can deport people without a hearing if he claims they are invading gang members. I'm excited to introduce our competitors who will be exploring the nuance of this problem before Scott Himsel introduces our panel of judges. Representing Donald J. Trump and Attorney General Pamela Bondi are our petitioners, Tobey Condon and Chris Runyon. Tobey Condon is a senior from Watervliet, New York. He is a PPE major with a classics minor. He is a brother of Phi Kappa Psi and works as a project assistant for the Lilly Library Ramsey Archives. He's also Wabash's first US-UK Fulbright Summer Institute participant, and after Wabash, he hopes to continue his studies in law or graduate school. Chris Runyon is a senior from Brownsburg, Indiana. He is a political science and religion double major. He serves the campus community as the president of Beta Theta Pi, president of the Pre-Law Society, and is a member of the Sphinx Club. He also works as a campus tour guide. Post-Wabash, he will be attending law school. Representing two detained Venezuelan nationals and others similarly situated, I knew I was going to struggle on that one. Our respondents tonight are Wade Wisler and Nicholas Kesler. Wade Wisler is a junior from Bloomington, Indiana. He is a PPE and arts double major with a minor in environmental studies. He is a brother of the Malcolm X Institute of Black Studies, a member of the Wabash lacrosse team, and serves as the annotator for his fraternity, Sigma Chi. After Wabash, he plans to address issues of sustainability and community as a lawyer or architect. Nicholas Kesler is a junior from Byron, Illinois. He is a major in philosophy with a minor in business. He leads on campus in many ways, including as a CIBE innovation consultant, a peer career advisor, and through several student-led committees. After Wabash, he plans on attending law school and ultimately practicing law in the Midwest. Please join me in congratulating all of tonight's competitors. I will now turn over the podium to Scott Himsel to introduce our panel of judges.
Well, good evening. Serving as our Chief Justice this evening is the Honorable Paul Felix, a judge of the Indiana Court of Appeals in Indianapolis. Judge Felix received both his bachelor's and law degrees from Indiana University. Prior to joining the Court of Appeals, Judge Felix was a prosecutor. He also served as judge of the Hamilton Circuit Court in Noblesville. While in that post, he helped create the court's youth assistance program. He also led Hamilton County's juvenile detention alternative initiative and presided over the county's drug court. Thank you so much for leading us tonight, Judge Felix. We appreciate it.
Thank you.
Our next panelist is the Honorable Doris Pryor, a federal judge who serves on the United States Court of Appeals for the Seventh Circuit. Judge Pryor received her bachelor's degree from the University of Central Arkansas and her law degree from IU Maurer Law School in Bloomington. Before assuming her current position, she served as a United States magistrate and in the U.S. Attorney's Office in Indianapolis. In the U.S. Attorney's Office, Judge Pryor served both as National Security Chief and as an Assistant United States Attorney. She has also frequently served as an adjunct professor, both at the IU McKinney School of Law and the IU Maurer School of Law. Thank you for joining us tonight, Judge Pryor. We really appreciate it. Third on our panel this evening is Karen Bravo, Dean and Gerald L. Bepko, Professor of Law at IU McKinney School of Law in Indianapolis. Dean Bravo received her bachelor's degree at the University of the West Indies, her JD at Columbia University, where she was a Harlan Fiske Stone Scholar, and her LLM at NYU School of Law. Dean Bravo is a well-known international law scholar who has focused her research on human trafficking. She also received an IU Trustees Teaching Award. Prior to entering the academy, Dean Bravo practiced law with international law firms in New York and Massachusetts, and she worked with an American Bar Association initiative on legal reform and education strategies in Armenia. Dean Bravo, we appreciate your service tonight. Thank you so much. And finally, our fourth panelist is the Honorable Daniel Petrie, who presides as judge of the Montgomery Superior Court No. 2 here in Crawfordsville. Judge Petrie founded this county's Family Recovery Court. He also presides over the Veterans Treatment Court. Judge Petrie received his bachelor degree at Wabash, where he majored in religion, minored in Spanish, and was a member of Beta Theta Pi fraternity. He received his law degree at IU McKinney. Before taking the bench, Judge Petrie practiced law with Henthorne Harris Wheelever in Crawfordsville, primarily as a criminal defense attorney. Judge Petrie, thank you for serving your alma mater tonight.
All right. I think we are ready to proceed. Are the attorneys ready to present their arguments in this case? All right. And who will be presenting first on the first issue? Mr. Runyon? Ben? Have we already decided how much time to reserve for rebuttal?
We will be doing 2 minutes, but Mr. Condon will be doing rebuttal.
Okay. You may proceed when you're ready.
Mr. Chief Justice, and may it please the court. My name is Chris Runyon, and along with my co-counsel, Mr. Tobey Condon, I represent the petitioners in this appeal, President Donald Trump and Attorney General Pamela Bondi, both in their official capacities. Today, I will be addressing the issue of whether courts are able to review the President's invocation of the Alien Enemies Act. Mr. Condon will address the issue of whether the President provided sufficient basis to invoke the AEA if courts are able to conduct such review. The lower court incorrectly held that federal courts are able to review the President's invocation of the Alien Enemies Act, and we ask this court to reverse their decision. This is for two key reasons. First, courts have never had the ability to second-guess the President's invocation of the AEA and have given the President complete discretion in carrying out his duties. This is because, as this court stated in Ludecky, the AEA is such a statute that completely precludes judicial review. And second, in cases involving similar executive powers as to what the AEA grants the President, courts have come to the same conclusion. Now, in regard to my first point, this court in Ludecky held that judicial review was completely precluded except for questions of interpretation and constitutionality. Now, the lower court assumed that this interpretation duty allowed a fact-intensive application of the law to the facts, but this is not so. As this court stated in Loperbright, to fulfill this court's interpretation duty, all the court needs to do is recognize the delegation that the statute gives to the president. And this is because, as this court stated in Eagle County, a fact-intensive application is much more grounded in policy decisions and outside of the wheelhouse of this court. Importantly, Ludecky limits the role of the courts because, as the court stated in that decision, courts lack the technical competence as well as official responsibility to determine whether AEA preconditions are satisfied.
Mr. Runyon, I have a question for you on that point. If courts can't interpret what invasion, one of the words that we're considering here today, if we can interpret what invasion means, but cannot apply that interpretation to any facts, what's the point of us interpreting?
Well, Your Honor, the interpretation that this court could do could take on a number of different forms. So, for example, say in the president's proclamation that he used a synonym for invasion or predatory incursion, but that is along the same line. So if he used a word like attack or a takeover or something along those lines, the court could then interpret whether the president's proclamation falls in line with what the AEA mandates of an invasion or predatory incursion. But it's not the role of the court then to, like you said, to do that fact-intensive application of the law. And this falls in line with numerous bedrock principles of precedent that this court has outlined, including in cases like Coleman v. Miller, where the court found that the field of foreign relations relies on factual and policy decisions that are entirely incompetent to examination and decision of courts. Importantly, as this court said in Shaughnessy, immigration law is vitally interwoven with foreign relations and the war power. And the AEA is a form of the president's immigration law powers. He is removing enemy aliens from this country that he deems are hostile. And this is why this...
On that, if you're saying this court cannot, or any court cannot challenge what the president's doing, are there any powers within our republic, our democracy, that can challenge the president on these things?
Yes, Your Honor. There are numerous other channels outside of this court to still serve as a check on the president. So the president is not completely without limits in this way. For example, Congress themselves could go in and change the statute of the Alien Enemies Act and limit his power or completely remove that power. Congress could also go into the Alien Enemies Act and say that everything the president needs to do needs to be reviewed by the courts, and that would be in line with this court's precedent in Biden v. Texas, that the court cannot look into those sorts of issues of immigration law without clear and affirmative intent expressed by Congress.
Counsel, let me stop you. I think you might be answering a different question. I think you might be answering the question you hoped my colleague had asked. What Judge is getting to here is the heart of the question is, what is the limiting principle on the president today? Not what Congress could do. What is the check with the Alien Enemies Act that we have in place today?
Yes, Your Honor. The limits on the president would be what this court found in Sterling, where if the executive were to go outside of the purview or outside of the limit of the scope of his statutory authority, the courts would then step in and have a role. So, for example, in Sterling, the court said that the Texas governor's use of the militia to limit the oil production was outside of what the Texas statutory authority allowed him. And connecting that to this case today, if the president were to say detain 3-year-olds and subject to them to removal under the Alien Enemies Act, that would go against or would exceed the scope of his authority under the Alien Enemies Act, because all those subject to removal have to be above the age of 14. So that would be where the courts could step in, but that is simply not the case today. The president is well within the scope of his authority under the Alien Enemies Act to remove Venezuelans that he deems hostile to this country. And it's important in this case that this is the first time that the Alien Enemies Act has been invoked outside the context of a declared war itself. So other examples include the War of 1812, World War I, and World War II. So it can be helpful for this court to look to other instances of the Alien Enemies Act or other similar statutes, being invoked, to help show why the courts don't have a role in review here. So, for example, you can look at the case of Martin v. Mott.
Has the Alien Enemies Act been utilized in other times in our country when we were not at
Not that I exactly know of, Your Honor. In the case of Eisentrager, though, the court questioned whether the president or President Truman's invocation of the Alien Enemies Act was valid, even though Germany had already officially surrendered in the war, but Congress had not actually deemed the war or ended the declaration of war at that time. But importantly, in Eisentrager, the court still found that though the bullets had stopped firing, the court still, or the president still, could deem alien enemies hostile in this country. So Eisentrager shows an important precedent that just because there's not an official declared war ongoing, or the bullets aren't still firing, there still can be hostile enemies in this country.
Can there be hostile enemies if the bullets never started flying? The cases you've cited are after the war. We were at war with Germany, it had ceased. Now, in this situation, there was never a declared war by any party. Is there any limit to that?
Well, Your Honor, if Congress didn't intend for the president to invoke the Alien Enemies Act outside of a declared war itself, it wouldn't have included the language of declared war, invasion, or predatory incursion. Those are all distinct terms with distinct meanings. Meaning if one of those things is ongoing, the president has the power under the Alien Enemies Act to use that emergency power to protect the citizens of this country. And Sterling, again, is a good example where there was an insurrection ongoing. And again, obviously that is not the Alien Enemies Act itself, but it's still an analogous use of power, and especially because the court in that case analogized the power under the Texas statutes to the president's power in Martin v. Mott that was challenged, which was under the Militia Act of 1795. The Militia Act of 1795 also largely mirrors the language of this case today, allowing the president to call up the militia in that case. And especially importantly to Martin v. Mott, the court said that they weren't allowed to second guess the president's ability to invoke the Militia Act of 1795. They couldn't second guess the president's decision making, whether there was an actual or threatened invasion ongoing.
I'm sorry, Mr. Runyon. In that Mott case that you're referring to, the court was dealing with whether to call up the militia for immediate defense during an actual war in Britain. How is that comparable to removing civilians who already live here based upon alleged gang membership?
Well, Your Honor, they still are a threat according to the president. And that's what's important, is there is a threat, an invasion or predatory incursion being attempted or threatened in this case.
Mr. Runyon, what is an invasion and what's a predatory incursion? Is that something that must be done by a governmental actor, or are there private citizens who then would constitute either invasion or predatory incursion? And who decides?
Well, Your Honor, for my argument today, I believe my co-counsel will address more of those definition questions. But at this point, when the president states in his proclamation that an invasion or predatory incursion is ongoing, that's the only type of thing the courts need to review. The courts don't need to go through this definition process that the lower court did. They simply need to look whether the president declared an invasion or predatory incursion is ongoing, and that is the end of their review. So, if you turn back to Martin v. Mott, the court said in that case that the president may not even be able to reveal all the information that he had access to, because in doing so, it could put in jeopardy national security interests. And this is supported by this court's decision in Curtis Wright, where the court stated that the president may not even be able to share the information he relies on because secrecy may be highly necessary and there could be harmful results in the premature disclosure of that information. And again, this is in line with this court's decision in Chicago Airlines, that it would be intolerable for the court to nullify the president's decision without relevant information properly held secret.
What is the national security concern?
Well, Your Honor, the president could have information that he used to declare an invasion or predatory incursion ongoing, that if he were to release it, it could let it could release information as to where these gangs are located and make them move so that all the security that's been going on, these gangs could then be tipped off to them being watched or under surveillance or anything like that.
Is there any check on that to say there is actually a concern and not simply a personal vendetta against a country?
Again, Your Honor, as far as I know in the record, the check of that would be that Congress could change the statutory authority, but the voters themselves could vote the president out at the upcoming elections or the other representatives to make the changes they want to see happen. But importantly, it's not the role of the courts to serve as that check on the president. It's also really important in this case to consider the ramifications of a decision in line with what the lower court held. If the president, every time he needed to invoke his emergency powers, had to go to the courts to prove the existence of what's actually ongoing, it would put numerous people's lives in danger. As this court held in Mott, every single delay to the president's use of emergency powers could be extremely dangerous to the people of this country. I see my time has expired, but it might briefly conclude. But for these reasons, we ask this court to overturn the decision of the lower court. Thank you.
Thank you, Mr. Runyon. All right, is everybody ready to? Mr. Condon, you may proceed.
Your Honors, may it please the Court, good evening. My name is Tobey Condon, and I represent the petitioners, the government, in this appeal. We win today because the Court of Appeals made a misstep in failing to recognize that the President provided sufficient basis to invoke the Alien Enemies Act to remove the Venezuelan nationals from this country. Our evidence is threefold. Resting on the powers and duties of the President, the Court of Appeals' overstepping of the separation of powers, and the validity of the President's proclamation in spite of the previous point. First, the President, as the Chief Executive, is under no obligation to provide findings of fact in the proclamation accompanying the exercise of the AEA. The President is in fact given wide latitude by the Constitution and Congress in matters of foreign policy, including war power and the Immigration Act, and his inherent Article II powers. The President has a duty to act swiftly. The lower court's choice to force the President to produce sufficient findings of fact as if he were a common plaintiff is problematic in two ways. First, it prevents the swift action demanded by the executive of our Republican form of government and inserts a judicial definition where the political branches purposefully did not include one. Congress must affirm the court's role in deciding laws like this, as seen in Biden v. Texas, where the courts declined to run interference without affirmation from Congress. With the AEA, there is no such affirmation. Congress purposefully did not include a definition or a standard of proof in the President's proclamation, but the court sees fit to add a definition of their own. Martin v. Mott says that every delay and every obstacle to an efficient and immediate compliance necessarily tends to jeopardize the public interest. In that case, the President was the sole and exclusive judge of the existence of an invasion. It is the same here.
Mr. Condon, if you say the President has zero obligation to produce the findings, but the statute that we're referring to here, the AEA, requires the President to make a public proclamation of the event. If he doesn't have to describe the event, why does the statute require a proclamation at all?
This is an emergency power, Your Honor, and it's important that the President let the public know about his decision and the summation of his findings. And the President, in his proclamation, did include such a summation. He pointed to the actions, the irregular warfare of the members of Tren de Aragua acting at the behest of the Maduro regime of Venezuela, and linked that to an invasion or predatory incursion.
Let's talk through then how that term is being utilized by the government. Invasion, predatory incursion.
These terms, Your Honor, are meant to be less than a declaration of war. In constructing the AEA, the Congress purposely employed discursive methods. They separated these with commas and ors to show that the scope and the threat would be less in each case, that a war is something more than an invasion, and that a predatory incursion is something less than an invasion.
I'm somewhat confused if we're utilizing this statute under the auspices of the President's emergency powers. So can you flush out talk me through why we're still able to utilize this statute if it's, as you described, less than.
The AEA also allows the president to enact it in cases of threatened or attempted invasions or predatory incursions. And this is what we see today, in which Tren de Aragua is threatening or attempting to perpetuate an invasion or predatory incursion of this country.
So let me jump in here, because it wasn't the president's proclamation explaining that there is an incursion, as in it was ongoing, currently, not a threatening of an incursion.
Yes, Your Honor. Part of the definition of an invasion or predatory incursion is the additional threat that this may allow Venezuela to take further steps against this country in harming its commerce and its property.
I guess what I'm getting at is, why do you get to come in here and argue the threatening language when that's not the proclamation, that's not the words the president used in his proclamation?
The language of the AEA is designed to give the president broad latitude in enacting it. And so the invasion or predatory incursion is what the president is proclaiming, but the threat as well is also sufficient to enact the AEA.
Can it be a predatory incursion or invasion when this is an activity taken by private parties, not a governmental actor?
It's not believed by this administration that the members of Tren de Aragua are merely private actors. The president's proclamation states that they are acting at the behest of the hybrid criminal state of Venezuela, and that they have been given orders to act directly from the Maduro regime to commit acts of violence and to harm the interests of the United States.
So the court has no ability and no power to interpret this definition, and must, you're saying, take as an article of fate whatever is stated by the executive?
The court must defer to the president's findings of fact. The court also has an ability to interpret the meaning of the statute, but in Al-Bahani v. Obama, it was found that application is separate from meaning, and that application is inherently political and outside of the realm of the courts.
However, you said we must defer to the findings of fact, but there may be secret. So how does that work? What is the check? We have a system of checks and balances in our republic. Where is the check here?
The check is that the president is the most democratically accountable member of our government. He was voted in by the people that he appoints to help him make these decisions, leaders of the National Intelligence Services and departments of state, are confirmed by Congress, who are themselves voted in by the people, and each member in this process has an oath to uphold the Constitution. It's important to note that Marbury versus Madison and more recent cases such as Trump v. Casa shows that a president has an obligation to follow the law and uphold this constitutional oath, but that this does not automatically give the courts the authority to police that obligation. In Marbury versus Madison, this court held that the president had violated his obligation, but in the same breath said that they had no ability to police that obligation. In Loper Bright v. Raimondo, this court held that the best reading is sometimes delegation to the president.
We're not suggesting, though, because the president is elected, that there is no checks and balances.
There are checks and balances upon the president, and this comes from Congress, who has the right at any time to repeal the law or change the parameters of it. Dalton v. Specter in this court held that if a presidential decision is involved, that the best reading is that there is no judicial review, which again points to my fact that the Congress must affirm the court's role. Coleman v. Miller says something similar, that foreign policy considerations, of which the president's invocation of the AEA is one, is entirely incompetent to the examination and a decision of a court of justice.
Question I have that's kind of off the track here, but the proclamation seems to be against Tren de Aragua alone. However, the statute requires that it be an action by any foreign nation or government. So is this proclamation against only Venezuelan nationals who are members of TDA, or all Venezuelan nationals in the United States would then be subject to removal under the AEA?
The language of the AEA does not require that the Venezuelan nationals be members of Tren de Aragua, but it seems that in the proclamation, the president is focusing on these members as an armed branch of the Venezuelan government. Rather than giving broad deference to the president's proclamation demanded by cases like Mott, Ledecky v. Watkins, and Sterling v. Constantin, the court uncharitably interprets the president's proclamation. It brands as evidence as mere conclusory statements and freestanding labels that are not relevant findings and compares this against the court's own artificial standard of proof. It does not acknowledge that the AEA applies to threatened or predatory incursions in its dissection of contemporary definitions. The key case in this matter is Ludecky v. Watkins, in which the court was interpreting the president's application of the AEA before Congress had declared war against Germany. And this speaks to the fact that this AEA is an emergency power and that the president must have the ability to act free of concern of retaliation from the courts, that in a situation of intense political delicacy and matters of foreign policy and foreign affairs, that the president must have the freedom to act in the best interests of this country, and the court upheld that in Ludecky, stating that the full responsibility for just exercise of the AEA was placed where Congress had constitutionally allowed it on the president. The president's determination, as we have discussed here earlier, is that in enacting the AEA, he may reasonably have based it on sensitive information that would be harmful to national security, citizens, and even Venezuelan nationals if it were made public. The choice to withhold this information is, again, a delicate political decision, one that the president is best suited to make and that judges are the least well suited to make. This has been discussed in matters such as Chicago and Southern Airlines, in which they stated it was intolerable for the courts to nullify the president because he may be operating on secret information. The actions outlined in the proclamation, aside from the secret information, clearly show that Tren de Aragua is engaging in an invasion or predatory incursion, even according to the lower court's definition. This is similar to the context of when the court enacted the AEA, or when the Congress passed the AEA during fears of the quasi-war with France, in which a paramilitary arm of the French government, the French privateers, were threatening and committing an invasion of American commerce, and that the president had the ability, absent a declaration of war, and in a situation of, I see my time is concluded. May I have a moment to?
You may finish that statement.
That the president had the duty to act swiftly and that the AEA empowered him to do so. For the above reasons, we humbly request that this court overturn the decision of the Court of Appeals. Thank you.
Thank you. Ready? All right. Mr. Kesler, you may proceed when you are ready.
Good evening, Your Honors. May it please the Court. My name is Nick Kesler, and I represent the respondents in this case, being Zebra and Gazelle. The question before this Court is whether the judiciary has the power to review the President's invocation of the Alien Enemies Act, and we submit that it does. This case challenges the President's 2025 proclamation under the Alien Enemies Act, in which he declared the Venezuelan-based gang, known as TDA, had carried out a predatory incursion or invasion against the United States. Relying on that proclamation, the government detained Zebra and Gazelle, two Venezuelan nationals residing lawfully in the United States, and ordered their deportation as enemy aliens. We do not dispute that the President may act forcefully in defense of the nation, but the Alien Enemies Act sets strict legal conditions. It applies only at a time of declared war, invasion, or predatory incursion by a foreign nation or government. Therefore, there are three reasons why this Court should hold the President's invocation of the Alien Enemies Act subject to judicial review. It is the Court's duty to interpret what the law means. History and text shows that the AEA only applies to military actions by nations, not crimes by gangs. And when individual liberty is at stake, courts must ensure that executive power remains within its lawful bounds. It is the Court's job to interpret the law. The judiciary has a constitutional duty to say what the law is, even in matters touching national security. As the majority opinion here explains.
Looking at the history and purpose of the Alien Enemies Act,
Could you repeat the question, Your Honor?
looking at the Alien Enemies Act and the history around when that act was adopted, I think 1798, counsel on the other side suggested that Marbury has already outlined for the courts where the line is in regards to the president enforcing or invoking emergency powers, as you just articulated, on behalf of the country, protecting or preserving the country. And there's a suggestion that Marbury tells the court that we are not the police or the policing of the president in this particular context. Looking at the history of that case as well as the Alien Enemies Act, how would you respond?
Well, Your Honor, the history of the AEA is that it's been invoked 3 times, in 1812, 1917, and 1941.
What's significant about those dates?
In all 3 of those cases, we were at declared war, either just before or after declared war. In 1812 being Great Britain, 1917 being World War I, and then 1941 being World War II. And with that, to go off your second point, as Marbury explained, the majority explains that courts must interpret the AEA's words and decide whether the president's facts meet the meaning of the statute. And this is consistent with in Ledecky v. Watkins, where this court made clear that although the president's finding may be respected, and they have to be, courts may review questions of interpretation and constitutionality. And following that, in Sterling v. Constantine, the court rejected the notion that the executive discretion places actions beyond judicial reach.
Are you suggesting then that the words invasion and predatory incursion are just extra words in the statute?
No, Your Honor. I'm suggesting that those words do not have the exact meaning that the president is saying that they do inside his proclamation.
Place them in context.
Yes, Your Honor. Early sources confirm that its trigger terms refer to state-directed military acts. In the Johnson's Dictionary of 1773, it defined invasion as a hostile entrance into the possessions of another. And in the Webster's 1828 dictionary definition of predatory incursion, it defined that as the entrance of a hostile army for conquest or plunder. And then even the president himself, in James Madison, in his report of 1800, said that invasion is an operation of war. The majority therefore concluded that a predatory incursion described armed forces of some size and cohesion directed by a foreign government or nation. In this case, we do not have that. We have a criminal gang that is directed by TDA, not affiliated with Venezuela, that the president claims is committing illegal migration, drug trafficking, and irregular warfare in this country. That is not the modern-day equivalent of sending an army commanded by Venezuela.
Mr. Kesler, aren't we obligated to interpret the statute with respect to current events? So if I may pose a hypothetical, if a group of cyber criminals were to target the United States, and those cyber criminals were from a particular country with perhaps some connection to that government, would the president be able to declare that that was an invasion or a predatory incursion?
No, Your Honor, not in this case. Because of interpretation, as according to Ledecky, that is in the times that the statute was written. The terms, so we have to take those terms as when they were written and what their statutory meaning was back in that day.
So we are not, as modern people, allowed to interpret the language in the context of current events.
Not according to the statute, Your Honor, no. So with that, these historical meanings that I described are not just background. They define the limits the courts must enforce. The majority makes clear that interpretation implies the application of law to the facts. And by confirming that proclaiming without more does not meet the statute's terms, the court shows that review is necessary to determine whether the president's factual findings fit the statute's meaning. We do not have any facts in this case and are not asking the president to reveal any of the secret intelligence information that you have. But there must be some factual basis for invoking the AEA under this statutory language because of how different this is from the 3 other invocations of this
So
act.
is the argument that if the president can only base this connection off something that is a national security secret, that he has to either divulge that or cannot invoke the AEA?
No, Your Honor. In that scenario, we would look at the proclamation that the president issued. And in this case, his proclamation did not include any sort of information that would portray the TDA to actually conducting a predatory incursion or invasion.
And if that information is only of a secretive nature, there's no publicly available information, but the president through national security apparatuses would know that, is he obligated to include that if that's the only information available?
He's not obligated to include anything that would really go deep into secret intelligence, but we do need some factual basis when looking at this statute to determine if the statutory language meets his definitions of what he is claiming.
What standard of review are you proposing for us in regards to the deference that we should give to the president's determination?
Well, Your Honor, I'm supposing that we should have the court's review, as Ledecky found, in questions of interpretation. And with that, in this case, there's two main terms that the president uses under this statutory language, being predatory incursion or invasion. I'm not asking that they go deep into the secret intelligence information, as that is conclusive, and the president must have that information sealed. But what I am proposing is that the courts use this interpretation and determine whether his facts meet the language of the statutory terms as it was written.
It is the suggestion that the president has put in the proclamation that TDA is perpetrating, attempting, and threatening an invasion. Why is that not enough?
Well, Your Honor, that's not enough because of the meaning that the statutory terms have. So as I said, with invasion and predatory incursion, what he says TDA is doing would not constitute either an invasion or predatory incursion. So I'm saying is that he needs to include a little more information that is not secret intelligence so that the courts have the ability to review and see if his language fits the statutory terms of those meanings.
Circling back to Mulberry, why is that? Are you not asking us to police the president's use of the emergency powers?
Well, Your Honor, I'm not asking the courts to police because in those times, what the president says is conclusive in the times of war powers. This is a war power, but he is invoking it in times of not a state of war, as seen. The 3 times that it has been invoked, it wasn't a state of war. So therefore, his evidence and fact finds were conclusive. In this case, it's not a war. It's the 2 other terms, predatory incursion or invasion. So therefore, there needs to be some statutory interpretation of those meanings to determine if he fits under the statute's language.
I suppose there's a genuine invasion underway, and Congress, for one reason or another, is not working. Is the president now supposed to wait for federal district courts and circuit courts, and then potentially even the Supreme Court, to review the president's determination of that invasion before can actually use the AEA?
Certainly not, Your Honor. If there was a true invasion, it would be declared and he would be subject to keep his findings secret. In this case, he claims that there is an invasion, but we have no evidence of an invasion. What we have is what the president is saying constitutes as an invasion. If there was a true invasion, then it would be known that there's an invasion. But with that, it is not in this case.
What is a true invasion?
Your Honor, an invasion would be, as according to Johnson's dictionary definition, a hostile entrance into the possession of another with armed forces and state-directed military. With that, I'd like to move into my third point, is that courts must act when liberty is at stake. Even in emergencies, individual rights remain protected by the law. Sterling v. Constantine reaffirmed that when private rights are affected, courts retain a role in judging the use of war powers. And in Johnson v. Eisentrager, this recognized that courts may ascertain the existence of a state of war and decide whether a person is properly classified as an enemy alien. And as the majority explained, Sterling thus supports the proposition that when private rights are involved, courts retain some role. Here, Zebra and Gazelle are detained and face deportation solely because the president called their group an incursion. Habeas corpus exists precisely to test these such detentions. Without judicial review, the president's label would be the law itself.
Right, you cite to the Sterling case just now, but in that case, didn't the court hold the governor's determination of an insurrection was conclusive?
It did, Your Honor, but what it did find is that the courts still retain a role in reviewing the use. They did find that his proclamation of that was conclusive, but they looked back and reviewed it to determine that he really didn't need to call in the guard in that case. The majority therefore emphasized that interpretation cannot be just an academic exercise. That principle carries special weight when liberty is at stake. Sterling shows that executive necessity does not get rid of judicial oversight. The court's review ensures that individuals are not deprived of freedom based on an overextended reading of wartime powers. Protecting liberty is therefore central to the judiciary's constitutional function. Your Honors, this case is about legal meaning. The Alien Enemies Act gives the president power only in time of declared war, invasion, or predatory incursion by a foreign nation or government. None of these conditions exist here. Therefore, the judiciary's role is to interpret state statutes, which ensures the Congress limits remain and that individual liberty is not surrendered to the executive. Therefore, we respectfully ask this court to affirm and hold the President's invocation of the Alien Enemies Act is subject to judicial review. Thank you.
Thank you. Mr. Wisler, you may proceed whenever you're ready.
All right. Your Honor, may it please the court. I first want to address some claims from opposing counsel that the lower court put the president in an intolerable situation and prevented him from exercising the wide war powers that he has. But his exercise of war powers isn't present here. What he is attempting to exercise is a statute passed by Congress. Second of all, they claim that the lower court asks the president to give up secrets of a nature that is not for the court to be reviewing. I contend, and my clients contend, that we don't ask the president to give up secrets, simply that he gives enough information to satisfy the statutory requirements. The requirements are that there is an invasion or a predatory incursion. We contend, based on the Webster's Dictionary from 1828, that an invasion is an entrance of a hostile enemy, hostile army into a country for the purpose of conquest. Looking at the context around the passage of this statute, we see that it's when the United States is preparing for war with France, and any sort of attempt to define the word invasion in the context of the statute outside of a war context would be inappropriate. Moving on to the word predatory incursion, the Webster Dictionary from the same year defines the word predatory as plundering, pillaging, characterized as plundering as a predatory war. An incursion as an invasion without conquest or applied to the expeditions of small parties or detachments of an enemy's army.
So if the statute lists declared war, invasion, and predatory incursion disjunctively, as it does, if all three require the same level of military force, why did Congress use three different terms?
Your Honor, I don't contend that Congress meant the same thing by all three terms. Just because there are three terms and each having different meanings, as you suggest, that doesn't decide whether each term requires a certain level of military action. Congress simply could have been referring to three levels of military action. One, declared war, which is decided by Congress in declaring war with another country. An invasion, as we see, a lower level, a hostile, the entrance of a hostile army into a country for the purpose of conquest. And the third, lowest level of a predatory incursion being expeditions of small parties or detachments of an enemy's army.
If Congress has the power to declare war, but it is referring in the statute to predatory incursion and invasion, is it not delegating to the president the power to declare that there is an invasion or predatory incursion?
No, Your Honor. The president is still required in the statute to provide findings of fact that those events actually occurred. If the president were able to simply claim that there were an invasion or a predatory incursion, and that be absolutely conclusive, there would be no check, as you questioned opposing counsel. There would be no check in the statute. This court today is absolutely at the liberty to interpret the meaning, the original meaning of those words, and apply it to a modern context, that being the proclamation.
But how broad is the scope of our interpretive power? Are we the check on the president?
Yes, Your Honor. The Supreme Court interprets statute all the time and applies their interpretation of that statute to the people that exercised it.
But if this were to be a non-justiciable political question or a question of national secrets, does this court continue to have that power?
Yes, Your Honor. I believe that this court has the power to decide whether or not a statute was invoked properly. And the court today has the responsibility to look at the proclamation and decide if it meets the statutory requirements. We hold that it doesn't because of the definitions that I gave, but also because of contemporary writings and references to
Chief
the words.
Justice Felix asked an interesting question that required us to somewhat take the facts that we have in front of us outside of this context. If it was not TDA, Venezuelan, as you described, your counsel described as just a gang. If we were to insert, instead of TDA, the country of Venezuela, is it your suggestion or the principle that you're wanting us to provide when you say more facts before the president can react? Where would those facts be disclosed? And to whom?
In the proclamation, Your Honor. And we contend that the president's proclamation does not fulfill the statutory requirements. He uses the term mass illegal migration, which is not in the statute. Although mass illegal migration was possible in 1798, Congress chose not to include that, and we understand that that does not fulfill the term invasion or predatory incursion. He also uses the words drug trafficking, which is also not in the statute, also possible in 1798.
Speaking of that, during the founding era, couldn't enemies have poisoned water supplies or food? Wouldn't that be a predatory act?
No, Your Honor.
Why is using drugs to destabilize society categorically different?
Because we have defined predatory incursion and invasion as requiring the action of a foreign country's military. And France, for example, could have tried to poison members of the United States in 1798, but if they had done so at that time, it would not have applied under this statute.
Does it require direct military action from another country, or if there's an agent appointed by that other country, could they be subject to the AEA with those actions?
No, Your Honor. We argue that it must be the military of a foreign nation. This is also supported by the fact that the AEA has never been invoked under circumstances outside of a foreign nation's military actions against the United States.
Can we not accept that TDA is working on behalf of Venezuela, Venezuelan government?
We do accept that TDA is working on the behalf of the Venezuelan government, but they do not qualify as a military force.
So your strongest dictionary definitions require, as you are maintaining, a hostile army or a military force. But those same dictionaries define those same words as a hostile entrance or an encroachment. Why do the military-specific definitions control?
Because this statute was passed in preparation for war with France. Those words were used by Congress in a military context. And the United States did, in fact, go to war with France in the quasi-war shortly after the enactment of the statute. Any definition of the word invasion or predatory incursion that ignores the military context in which the statute was passed are irrelevant. To give some more meaning to those words, invasion and predatory incursion, I'll point you in the direction of President John Tyler's letter to Congress in 1884, where he wrote that the war which has so long existed between Mexico and Texas has consisted altogether of predatory incursions. He defines it as a war. Since your last session, Mexico has threatened to renew the war and either made or proposes to make formidable preparations for invading Texas. This letter was likely referring to a predatory incursion in which a Mexican general entered Texas with 1,400 troops. This goes towards our definition of predatory incursion, that requires that these actions are taken by the military force of a foreign nation. Another piece of our argument is that looking at the context around the enactment of the statute is that Congress also passed the Alien Friends Act. And as we know, these statutes were passed alongside several other acts known as the Alien and Sedition Acts. The Alien Friends Act was one of them. The Alien Friends Act did not require hostilities with a foreign nation at all, while the AEA, as I've argued already, demands specific categories of military hostilities. The two statutes were meant for different purposes, and the two of them side by side show us that the AEA is meant for military, defending against military threats, while the Alien Friends Act was meant for detaining and removing individuals who the president may have thought were hostile. It gave the president, the Alien Friends Act, gave the president the authority to remove anyone as he may judge dangerous. That act gave great deference to the president's considerations, while this act that the court interprets today sets strict requirements for him. The Alien Friends Act expired over 200 years ago, in 1800, and Congress made clear that the president could not undertake the same actions as he could under the Alien Friends Act, under the Alien Enemies Act. The only possible way that the Alien Enemies Act applies today is if the proclamation identified a predatory incursion by armed forces of a foreign nation or government. The proclamation's findings, while describing actions that are dangerous, do not describe actions comparable to an organized military hostility required by the statute. We argue that the Alien Enemies Act was improperly invoked.
You're out of time, counsel. Can you provide your conclusion?
Yes, Your Honor. We request that the court affirm the lower court's ruling. Thank you.
Thank you. I believe we have a 2-minute rebuttal. Is that correct, Mr. Condon? Okay. You may proceed.
Thank you. May it please the court. To begin, I'd like to comment on opposing counsel's definitions and employment of the use of the Johnson Dictionary and the Webster Dictionary. As this court pointed out, these definitions make just as much mention of a military force as they do not make mention of a military force, only in cases of intrusion upon the property and rights of another, which is what is happening here in the president's enactment. Opposing counsel fails to understand the term war powers, seeing it as exclusively involving cases of states of war. However, this court has held that war powers are closely tied to foreign policy and matters of immigration. They're as much as about preventing war and ensuring harmony as they are in executing war. This is because the AEA gives the president the power to deport these nationals and ensure that a case of war does not come to pass. Respondents would have the president wait until there was a declaration of war, nullifying the AEA's most important power to give the president the ability to act in cases of ambiguity in which political decisions are vital. This sets up an impossible situation for the court in having to ask the question, how far is enough? Opposing counsel would have the court engage in the kind of sophistry and prophecy that the prize cases and other cases exclusively wanted the court to exclude themselves from. Meanwhile, an invasion or predatory incursion is threatened or already underway, as the president's enactment states. The knowledge of an invasion or threatened invasion or an attempted invasion is purely a political matter, but opposing counsel would have the court go arm deep into this issue and immerse themselves in questions that the president and Congress and the people that the president appoints to be around him are best equipped to handle. It's also important to note that opposing counsel makes no mention of the AEA's statement that threatened warfare or threatened invasion is also justifies the execution of the AEA. This further underscores the importance of the presidential determination. I see that my time is concluded. May I have a moment? Thank you.
You may conclude.
We humbly request that the court overturn the decision of the Court of Appeals. Thank you.
Thank you. All right, I believe that does conclude the argument today in this matter. The court will stand adjourned for its deliberations.
All rise. Be seated. All rise.
Thank you. You may be seated. All right, the first thing I'd like to do today is to acknowledge the exceptional work of all four of our competitors in the argument today. You can tell that they have put in an amazing amount of time and energy into the preparation of their arguments, and it showed your exceptional work. So congratulations. Now, I don't know what the normal amount of time it takes for judges in this type of competition to come up to a decision on the top oralist, but from the number of times that we had people coming in to find out if we were done or not, it seemed like we were having a very difficult time. But before we announce the top oralist, we would like to take a moment to go down the table with each one of us giving some amount of constructive criticism and or commendation as we see appropriate. We'll start over here with Judge Petrie.
So, gentlemen, I was a student here, and I will say what you're doing in your undergrad years far exceeds anything I could have ever done. I think the future is incredibly bright for all four of you. One thing that truly impressed me, having done oral arguments previously, is your ability to think on your feet. We would ask questions. You would bounce back, respond to them, get back into your argument without being rude about it, without cutting back, seeming like we had wasted your time, which often happens in appellate arguments. You all did a great job of just going with the flow, which you made seem very easy to the audience, but we're all well aware that is not a simple thing to do, so congratulations for that.
I thought all four of you did an exceptional job. Exceptional. One of the hallmarks of a great appellate argument is when the judge and the litigator are able to dance together. And you all really allowed the questions to direct your movement. You were able to move away from the script and really engage in a conversation. And I thought the only way that these four individuals can do that is because they've spent time with the material, they've invested in their argument, and more importantly, were able to see the other side, the perspective. You anticipated where the question was going, and you got ahead of it. And I thought that was exceptional. For those that are in law school, that is a skill set that you pick up maybe your third year, or you really grapple with it your first or second year as a lawyer. And the idea or the notion that you all are doing that critical thinking now and engaging in that way on a logical perspective is just unreal. And so the discussion we were having in the back, as Judge Felix alluded to, I think the first 10 minutes were the judges talking about, they're just an undergrad. Like, none of us could believe how well versed you were. One of the things that I wanted to just highlight, and this will, I think, definitely going into law school, and you all did it masterfully tonight, is being able to engage with the court, irrespective of the point that you want to make. Answer the judge's question, because in appellate court, we have not all talked to each other. But the questions we are asking somewhat reveals what the judge is thinking and the way the judge is headed. So what you want to do if you're listening to the question is answer the question in a way that you are anticipating, right? If this was in a decision, how would this look? And so when you hear us bouncing off of each other, that's the clue. And I thought you all did really good at engaging. So exceptional job, really enjoyed it.
Very good. All right, so I am going to emphasize one thing, and that is how well I thought all of you, and I'm really kind of repeating Judge Pryor here, how well you moved from our questions and your answers back into your arguments. You all did it so well, and many times better than many practicing attorneys are able to do it. I have watched many attorney stumble as he or she has attempted to go from answering our question back into the argument. It's not an easy thing to do. So the way that you have all been able to master that skill is very impressive. And I don't know if anybody has said it yet, but if Professor Himsel, Scott, where is Scott? If you are involved in the way that they have mastered these skills, I think a commendation to you is in order as well. Thank you.
My remarks will be brief. I found you all very impressive, loved the way that you were not fazed by the questions, even when we piled on. And really, the discussion in the deliberation room, you should all be proud because these real judges compared you favorably with practicing lawyers who have appeared before them. And I think that's a really high accolade for you to take away.
Great job.
I think so. All right, so based upon the long and arduous deliberations of the judges here tonight, we have decided that the recipient of the Wabash College Fall 2025 Moot Court Top Advocate Award should go to Tobey Condon. Congratulations.
Congratulations.
Congrats. Great job. I believe that we also have finalists awards for Mr. Runyon. Congratulations.
Mr. Runyon, I wanted to shake your hand.
And so did all the judges. Remember Judge Dean Bravos. And Mr. Wisler. And Mr. Kesler.
Would you join me in thanking our panel of distinguished judges? And I join the panel in congratulating not only our winner, Tobey Condon, but all of our finalists. I'm glad I wasn't called upon to make this decision. It's my pleasure to announce the winner of a second award. The Floyd Artful Advocacy Prize honors the memory of Douglas B. Floyd, a Hamilton County lawyer remembered by his colleagues as an artful advocate of causes he believed in. The winner is to be not only a successful advocate, but also kind, tactful, and principled. As lawyers might say, our winner succeeds without scorching the earth. What we seek with this award is not only winning qualities as an advocate, but also a winning disposition, someone who can take the heat with a smile. Funded by gifts from Doug's colleagues, friends, and family, given at the time of his death in 2001, Doug's wife, Lisa Floyd, and his son, Riley Floyd, Wabash class of 2013, established the prize in 2019. Selection is made by the faculty members who organize Moot Court, and the award may go to any of the 4 Moot Court finalists. We're very happy to award the Floyd Artful Advocacy Prize for this school year to Chris Runyon. We're so happy that you joined us tonight. This is one of the tougher rounds to judge that I've ever seen in this competition. I add my congratulations to all of the students. We have a reception waiting for you in the Littell lobby, which is right out of those doors. But before the reception, we ask everyone who participated in this year's competition, either as advocates or judges at any round, to join the finalists and the final round judges for a photo. So please start heading up in this direction, and thank you again for joining us tonight.